recommending, or do any of the person who are the review team personally recommend marijuana?
I don't know the answer to that, Representative Simpson. And I can tell you that neither Dr. Sulak nor Dr. Boyd were involved in this.
Thank you.
Sure.
Representative Hammond. Thank you. Could you elaborate on what you meant by your concern that physicians might have a capacity issue?
Well, yes. I mean, just that because this may continue to evolve, but today this is still enough out of mainstream medicine that it's not like every primary care physician in the state is going to be willing to take this on. There's enough additional compliance effort required to be in keeping with this law that not every physician is going to want to take that on. That's what we've experienced in terms of the questions we get from physicians.
Okay. I didn't read the bill that the physician would have to take that on. Is that not the case?
No, well, no, but patients are obviously going to ask. I guess that's my point. They're going to be fielding requests from patients if we're broadening the scope of conditions.
I think I understand. So the capacity you're talking about is the doctor would then have to educate themselves on this new aspect that they're not currently having to educate themselves on that.
Exactly, and not all of them are going to be willing to do that.
Thank you.
Representative Mallory, do you have a question?
Thank you, Mr. Chair. Thank you, Andy. Am I to understand that whatever training, medical training is given now is restricted to CMEs?
We have expended quite a bit of effort in CME on the topic from a largely legal compliance standpoint, but as I've said, we have involved a clinician when we can get Dr. Woywick, for example, to be available. I really can't speak to what sort of training in medical school there may be about any sort of alternative types of therapies. I don't know the answer to that.
Thank you. Ms. LeClay, I think in the exchange between yourself and Representative Sanders, there was reference to another bill that's from her recently. Was that?
I think Representative Sanderson was talking about LD 422, the bill dealing with Lyme disease.
Okay. Thank you very much.
Thank you.
Oh, I'm sorry. Representative Brisby.
Thank you. Just to follow up on Representative Sanderson's question, do you think that in the next few months, if not sooner, you could maybe send a poll out to your members to find out what's going on and their thoughts on that?
Sure.
And my other question is, you said you're opposed to LD 23, and you're neither for and against for LD 35. Is that correct?
No, we are taking no position whatsoever on any of the other bills before you today. We are only speaking to LD 23.
Okay, thank you.
Thank you very much.
Thanks.
Still taking testimony in opposition. Good morning, Mr. Austin.
Good morning. This morning, right?
It is still in this Eastern Daylight Time.
Senator Brakey, members of the committee, my name is Jeff Austin. I'm here on behalf of the Maine Hospital Association to speak in opposition to LD 35. We do not have a position on LD 23. And to be clear for you, as I'm sure you know, when we discuss this as the administrators of the hospital. I'm on the administrative side and not on the clinician side. And they discussed this issue in quite some depth at our last policy committee meeting, and I'd say they focused on the issue of the oils and the children with the debilitating seizures. And I'd like to personally thank Ms. Brown and Ms. Meehan for meeting with me and educating me about what they're going through, how it works for them and their children. I greatly appreciate that they graciously offered me some of their time. Let me clear up a few possible misconceptions. As they discussed it, I heard no objections related to this being illegal. I heard no objections related to reefer madness. I heard no objections related to criticisms of marijuana as a drug. They have two concerns, but it is not rooted in any of those things. Quite frankly, they are looking for a path to say yes. I think, as you've heard, many of them are not saying no, and it is occurring. We are not oriented to try to block this activity, at least as far as the administrators who are in the room discuss this. They are looking for a path to allow it to be used. We are also not the defenders of the FDA. Trust me, the irony of us, of hospitals being able to prescribe and use opioids in great amounts, but under FDA rules, but not marijuana or marijuana-based products, is not lost on the administrators. We are not the FDA Defense Association. The two issues are federal licensing and clinical. Let me talk about federal licensing first. I think you heard that we are not federally licensed. I think that's technically accurate, but somewhat misleading. In order for a hospital to participate in the Medicare program, you have to meet the conditions of participation, which is the name of the regulation that the federal government promulgates in order to participate. That's half of our patients. If we're going to be a Medicare institution, we have to follow those regs. Those regs do not allow for the administration of non-FDA approved medications. Now, I appreciate that the sponsors of the bill are trying to help by saying hospitals don't have to affirmatively administer the medication. If I understand the intent of the bill, it's to allow self-administration. I'm not sure that that's a distinction that would get us out from under the CMS regulation, but we appreciate that that's, I think, the goal of that phrasing in the bill and that way it's structured. So the Department of Justice regulations that you've heard, I have read them. I'd be interested to know the actual scope of them. They do say it covers all federal enforcement, but it reads to me like it is related to the criminal side of the world and not the CMS regulatory side of the world. There is a way to somewhat possibly address this, as you know, not address all issues, but some of this federal regulation. As you know, the federal regulation is enforced by the state. We have never received a letter from the state licensing entity saying that this would be a permissible use. Can you get one for us? That they, in their enforcement responsibility, will not find a violation of CMS regulations if this bill were to go forward and we would allow patients to self-administer. Can the state issue a stand-down letter? The second issue, I know my time is up, but
I'll let you answer for that.
the second issue is on the clinical side, and we don't really speak to the clinical side of the house. That is more for the medical association. But I would say this: you've heard a lot about the doctor-patient relationship and allowing that relationship to control the use of this substance. There may be conflicts, though, where one physician feels that this is appropriate for the care of the patient, and another physician has concerns. You need to be clear about what the bill does. It overrides the judgment of the second physician and says, you may not cease caring for this patient, even though the patient is is ingesting a substance and you don't feel is safe. So yes, you're being asked to respect the doctor-physician or the patient-physician relationship in some respects, but the bill is overriding any contrary position from the medical community. You need to be clear about what the bill does. Speaking to the legislation, I can't say I fully understand it. I mean, a lot of the sections are putting hospitals into the primary caregiver role. I'm not sure that that's necessary for the self-administration of the substance under the law, under the goals of what you're trying to pursue.
Are you going to give us written copies?
I will. It's changed substantially over the past 72 hours, which I'd like to get to in a second if I could. It's up to
Okay.
you.
Yeah, well, how has it changed in the last 72?
Well, let me just address a few other issues. We talked about the Lyme disease bill. This bill does not have any of the protections that you've seen in other bills, such as state licensing, medical malpractice, or the like. If you are going to proceed and say that this is okay, all of those additional protections should be in the bill. We believe the bill should be restricted to the oil and oil-based products and not be as broad as it is currently worded. We believe you should try to get a letter from the AG or DHHS that they will not, under their federal authority, take any adverse action against any federally licensed or certified facility if they allow it to happen. It was stated that nursing homes have this right already by the sponsor. That is inaccurate. You're deleting the language that allows the nursing homes to have a policy that prohibits its use. It is not currently state mandated to be used in hospitals. You were given the Illinois law. I haven't read the Illinois law, but I just read the summary from the Illinois Hospital Association. I believe it remains a permissive for hospitals to have restrictive policies on use. I'm not an expert in Illinois law. I've never read it. I just read the summary. I don't know that this is consistent with the Illinois law.
Just want to stop asking a question, because I think you need to move this to questions. So last session, this committee and the legislature, carved out something that worked on the nursing home side, and some of the concerns that we heard when we heard that bill were some of the concerns that I think that you sort of talked about with respect to CMS certification. We were able to, again, work those, come to a compromise with respect to the use of substances in nursing homes. What's different about hospitals? Why can't we do something similar here?
Because in this bill, you strike that compromise language.
Okay.
If you look at page 2, lines 27 to 29, I believe that's the compromise language
Okay.
they worked out.
But otherwise,
it's the nugget.
yeah.
It continues to allow, I'll read it for you. This subsection does not limit the ability of a hospice provider or nursing facility to prohibit or restrict the use or storage by a qualifying patient. So this doesn't exist in the form we were told in nursing homes today. So, but over the past 72 hours, and particularly with the issue of oils, we have a lot of flurry of emails about people discussing whether it is actually prohibited or whether it can be, under the current federal system, allowed for some patients to take some of these oils. And we would be interested in understanding, I know there's a lot of varieties out there and a lot of different strains with a lot of different content, but it is possible that some of these products may be permissible or not impermissible under federal law today. And this bill has kicked off a lot of activity on our side looking at that. Again, they are looking to try to find the path through the eye of the needle here to say yes. But I'll close by saying, I agree. I think the risks are small, that you'll lose your federal license or you'll lose your federal certification. Those risks are small. But they always appear really small, particularly small, when someone else is bearing it. Do you want to take on this risk for us and guarantee us that if we lose the federal certification, for every Medicare patient we treat, you will reimburse us? That's essentially the risk. It may be remote. It probably is. It may be small. I believe that it is. But is it so remote and so small that you're willing to bear that risk and put the state's financial circumstances at risk? Should there be a change? That's our concern. And again, I've got 2 kids. I do the same thing.
Thank you
No
very
doubt
much.
in my mind.
Thank you. Early on, you said that you do want to find the path to yes. And so I wrote down to ask you, what is the path to yes? But sure enough, you answered that. And it seems like a letter from the state authorizing hospitals to do this would provide some protection for the hospitals. Is that what you?
It would provide greater protection that if they would send a letter wearing their federal hat because they wear multiple hats. It's not enough to just protect us from state-based regulation, but federal as well. And see what CMS has to say about that.
So a letter from CMS.
From the state does the inspections on behalf of the feds.
Would this, if this became law, would this law provide you that protection?
No.
The same way?
No, just as it wouldn't from any other federal law that you put us in conflict with. I mean, they're afraid that they have to choose which law to break, either a federal law or this bill that you would be passing. So, as many have said, I'm not aware of a prosecution. I'm not aware of anybody getting sanctioned. I'm not aware of anybody losing a license. But the risk remains. You can reduce in the eyes of many the size of that risk if the federal enforcement entity, which is state-based, were to say, we're not going to pursue this. We believe this is okay. Under the DOJ guidance that has been given. That would help.
Mr. Malley, do you have a question?
Thank you, Mr. Olson. You say the risk is small, but if Medicare amounts to 50% of hospital revenues, how many billions of dollars are we talking?
Yeah, it's 50% of the patient load, and probably a third to 40% of revenues. It's in that magnitude. It's over $1 billion. So yeah, the risk is small. And again, it's awful small when you're not bearing it. But the consequences are great.
Thank you very much.
Thank you.
Anybody else here to speak in opposition to LD 23 or LD 35? Good morning.
Morning. My name is Scott Gonier. I'm here today representing Smart Approaches to Marijuana, Maine. We are a nonpartisan, all-volunteer alliance of parents, community leaders, and other concerned Mainers dedicated to informing Maine marijuana policy around the science of today's marijuana. I'm here specifically for this portion in opposition to LD 23. We do not take any position on LD 35. And I do appreciate how you've lumped the bill together in the name of efficiency. And I want to talk a little bit about the lumping that I've done looking at the slate of bills our organization has done on the slate of bills before you today. And it's actually LD 23 and LD 5. LD 5 would be eliminating the patient limit for caregivers. And my background is in substance abuse prevention. That's my day job. One of the things with a focus on youth, and one of the things that we always concern ourselves around, no matter what the substance, is access and availability. When I look at these two bills together, we're looking at basically allowing treatment for any condition that a physician will sign off on, and caregivers have unlimited on patients. Those two together raises significant concerns around diversion to youth. Which is the primary reason we're opposing LD 23 and then later LD 5. Earlier testimony talked about the sanctity of the doctor-patient relationship and, sort of getting politics at a medicine. The reality is that this law was created through politics. It was created through a referendum. This was medicine created through policy, not through science. Certainly, that said, we understand that there's promising research that shows medical marijuana can be an effective treatment for certain conditions. The problem is that we don't have that body of science for every condition. There are a lot of unknowns out there right now. I'll even, frankly, I included a study, even with our current list of allowable conditions, there's some mixed science with some of those. I hand you an example of a recent study from Yale University that looks at some possible complications with PTSD, where with some patients, it actually worsens symptoms and increases violent behavior. Again, stressing some. It's not the case with all, but as the prior person talked about, we're looking at risks. I mean, bearing the risks as a state posed to patients and to our communities. So that really boiling down, that is really the central concern of ours, is these unknowns around, there's a lot of research already that looks at the possible complications of marijuana in certain mental health conditions. We would be concerned of a patient being certified to use marijuana for one of those conditions, such as depression and anxiety, and then their condition worsens over time. So what is the check on that sort of situation? And again, with the risk of diversion to youth, I mean, while we're moving in one direction with our opiate addiction problem, with a prescription monitoring program and looking at prescribing patterns, these policies together looks like we're going in a different direction with medical marijuana, where we're broadening access, we're really loosening it up and creating more loopholes. And that's something, again, as someone who works in substance prevention, is something that's very, very concerning to me. So that is basically our position on that, and hope that's it. Any questions?
Thank you very much. Any questions? Senator Haskell.
Thank you very much, Mr. Gunner. You referenced a study. What I see here is the report of an editorial board of the psychiatric advisor on that study. Could you provide us with the actual study as opposed to the...
Yes, I could.
Thank you.
The link to the study right now, you have to have a subscription to get access to it, so I will get a copy from the committee. Absolutely.
Representative Campbell.
Thank you. And you said that it wasn't effective for some people with PTSD. How does that compare to other treatments for PTSD? Are other treatments effective 100% of the time? This is effective, say, 50% of the time?
I wouldn't have any knowledge of that, and really the point of raising that, again, is the risks that would be posed. So, and one difference between our FDA prescribed medicines and our medical marijuana is there's a different body of the science, there's a different process through which those medicines were approved. And, medical marijuana just hasn't gone through that process. It hasn't gone through the same scientific rigor. So our concern is with that percentage, however small or big, that are at risk when using marijuana for PTSD, we're concerned about how many lives it affects.
Any other questions? Representative Samuel.
Thank you for being here today. I'm just curious, have you ever looked at any of the case studies about patients who have, and read the many studies of patients who have used medical marijuana successfully to treat?
Certainly, and as I mentioned earlier in my testimony, we do recognize that it has been effective for some. Again, we're looking at population health, the totality of how many more people does this put at risk. We don't have the same sort of medical oversight and scrutiny as we do with our other medicines. So that's our concern, is that someone's going to be recommended marijuana for which it may actually worsen the condition because we don't have the same body of science behind that marijuana treating that particular condition. So again, it's population health that we're looking at.
Thank you very much.
Thank you.
So taking testimony in opposition.
Good morning, Carol Conley from the Christian Civic League. The Christian Civic League, first of all, I want to say to Senator Brakey and Representative Gattine and members of the Joint Committee, thank you for the opportunity to be here this morning. We typically don't take a position in regard to medical marijuana, and we like to leave that up to those folks in the medical community, folks like Mr. Gagne that was here that deal with these situations. But we are opposed to recreational use, so we're concerned that LD 23, LD 5 could open the door and also increase risk for abuses within the system. We believe that the passage of these bills could dramatically increase the risk of marijuana abuse, as physicians would be free to certify medical marijuana for any condition. And because medical marijuana is not subject to our present prescription monitoring program, the risk of the abuses in doctor shopping would also increase. The League is aware of the new contract with the Sheriff's Association, and we think that is a capacity issue there with only having 5 people to take care of the entire state of Maine. As we give opposition to these bills, it is not without compassion to the stories that we've heard here today. We are not opposed to the medical use of marijuana. It's the execution that concerns us. The League is also concerned about the prudence of removing the list of qualifying conditions. Studies show that marijuana could actually make the symptoms worse in some of these. The Yale study that Mr. Gagne just referenced, and also the Smart Approaches to Marijuana website recently refers to two studies from from Harvard and Northwestern in regard to the potential new studies in regarding to the effects of marijuana on the human mind under the age of 25. So there are really some new things that we think that need to be considered as we can move forward. The potential risk of the health to those who suffer from PTSD is a concern to the Christian Civic League, but it's also a concern to me personally. I have a son that served in Iraq and actually had to take a medical discharge, and part of that discharge was PTSD. And I have seen up front the negative effects of that in our family. And we're thankful for the treatment that he is getting, but I would hope that as we move forward that we would look at all these, especially these new studies on how best to harness the substance's medical properties while minimizing the harm to patients. I believe it's wise to refrain from putting policy ahead of science, and for that reason we're asking you to vote not to pass on LD5 and LD23. Thank you.
Thank you, Mr. Conlon. Any questions? Thank you very much. Still taking testimony in opposition. LD 23 and LD 35. Taking testimony now, neither for nor against either of these two bills. Good morning, Mr. Ward.
Good morning, Senator Brakey, Representative Katine, members of the Joint Steering Committee on Health and Human Services. My name is Peter Moore. I'm the Vice President for Advocacy of the Maine State Chamber of Commerce. And I'm here to speak to you today neither for nor against, but to try and provide you with some additional information as you consider LD 23. Our policy committee had a discussion about this issue, and it probably comes as no surprise to you, is that medical marijuana is in the workplace today, and employers aren't sure how they are to manage their workplace as a result of that. The law that passed gives employers very little guidance in terms of dealing with the potential of an impaired employee in the workplace. I spend much of my time in the room next door, and I talk about workplace issues, and I also have spent a fair amount of my career dealing with workers' compensation issues. Employers have concerns with regard to workers' comp. Providing a safe workplace for their employees is extremely important. Employers do not want employees who are impaired working and endangering either themselves or additional employers. But employers have no way to know whether an employee is impaired or not at the time. There are employers who engage in drug testing in this state, but drug testing only indicates the presence. It doesn't talk about impairment. And employers have said to me time and time again, we have concerns. We don't know how it is as we move forward into this uncharted territory. We are to deal with medical marijuana and keeping our workplace safe. Some employers have said it's just contradictory. I'm speaking to you in neither for nor against this particular bill, taking no position on the medical efficacy of medical marijuana, but merely to point out to you that expanding the use or how medical marijuana is used on certain medical conditions only provides additional confusion for employers. There is no roadmap for them, and it has been described to me in some ways as the Wild West of the workplace employment law today. As you consider whether you want to move forward with this bill, we would simply ask that you keep these thoughts in mind. And I appreciate the opportunity to provide you with our comments. Thank you.
Thank you, Mr. Gordon. Any questions? Representative Sanders.
Thank you. Thank you for being here, Mr. Gore. Are there any concerns expressed from employers about individuals who may be attending work with using narcotic pain relievers?
Absolutely. It all falls into the same category. It does fall into this, absolutely falls into the same category. But if an employee is using narcotics, I mean, the law protects employees who have a medical marijuana card. Those protections don't necessarily exist for someone who is impaired abusing prescription narcotics.
We're not talking about abuse here, though. We're talking about
Right, I
a
understand that.
legitimately written prescription by
I
a
understand that.
physician.
It continues to be a concern, is the answer to your question, yes.
So the break is a question again now. He knows he's only supposed to be on the bill, sponsor, not on the news.
I actually just had my question answered, so I'm good.
Help each other out.
Thank you. Have there been a number of workers' comp claims related to medical marijuana?
I don't know the answer to that question, Representative. I do know that the Workers' Comp Board and a hearing officer just awarded medical marijuana as a treatment for pain control through the workers' comp system. That's the first time that's happened. And that's been actually met with sort of a mixed feelings from the employer community. On one hand, it's new and they're not sure about it. On the other hand, some employers have stated that they would rather have someone controlling their their pain through the use of medical marijuana than opiates, which tends to have much more debilitating long-term effects.
Any other questions? Thank you very much.
Thank you.
Any other testimony either for or against LD 23, LD 35? Any additional information that people would like for the work session? Representative Berkson.
Do you think, I don't know how to go about that, get some information from the AG about how a letter could be worked or brought for us?
Yeah, and so again, I'd like to hear at the work session either from the department or from legal counsel about the issue that Mr. Austin raised about whether or not the state wearing its federal hat, to use this term, could send a letter to hospitals alleviating some of the risks that they've been facing. Representative Sanderson.
Thank you. I think it'd be interesting to find out if other hospitals, is there legislation in other states that have covered that? Probably that would be a good question for some of the advocates here, because you follow this legislation nationwide so closely, what states they are, what kind of language it is. So maybe we could use that for a baseline to start with before the work session. And if that information could get to us before the work session, so we could actually chew on that further, that would be great.
Thank you. Anything else? Okay, so I'm going to close the public hearing on LD 23 and 35. Turn the gavel over to my co-chair for the next two bills we're going to do, which are LD 21 and LD 560. I assume.
So it's been asked by the committee, normally we would be breaking now for lunch, but because of and we would normally take an hour lunch, but because of the amount of interest on the bills that we have today, I think we're going to take a 15-minute break so that the committee can run down, bring some lunch up here. I hope you don't mind if we are eating while this is going on. We're just simply doing that so that we can have more time for everyone to be able to share their thoughts. But hold on one moment. I haven't closed this yet. When we get back, we will take up the public hearing on LD 21 and 560. We will intend to be back at 12:15. So thank you very much.
Right. Now, did I really think that was 3? That was 3.